Hello and welcome everyone. Welcome to the Nest Egg Builders Show. Today we are so privileged to have Marc Garlett with us. He is a trust attorney in California, and he's my trust attorney also. And we are so happy to have him here because he's not only a real estate investor and the past president of Sierra Madre Rotary, but he is also a dynamic father and husband, and knows about everything there is to know about being a trust attorney and what's really important. He also has articles that show up in our local paper. And after I saw this article, I called Marc and asked him if he would come speak about this subject. So welcome, Marc. Please take it away. Now we can't hear you.
Oh,
there we go.
All right. All right, my apologies. I'm hitting buttons here. Okay, well, I was just going to say, Peggy is very kind. Thank you for that introduction. But I have to correct the record. I don't know everything there is to know at all. I am constantly learning, and that's one of the reasons I love coming here on Tuesday afternoons, because I'm always learning so much. And that goes with real estate. It goes with the law, and it certainly goes for trusts. I do love this area of the law because it really gives me a chance to be creative and do some neat things for families and use the power of the law for good, which oftentimes it is not used for. And so it's one of the things that I do love about it. But I thought today, rather than come in and do a PowerPoint for you, I'm just going to kind of talk you through the way I look at some of this stuff. And we're going to talk about the cost of dying, really, and looking at what we can do to alleviate that or mitigate that cost a little bit for our families, not for us, because at that point our troubles are over. We don't really care. But the people that we leave behind, we do care about. And that's what this area of law really helps us do, is continue to care for them and provide for them and make things as easy as possible on them in difficult circumstances. So I'm just going to kind of throw some things out, and a lot of smart people in this group. Probably most of you are smarter than me. So I'm happy to entertain any kind of additional thoughts or questions as we go through this. But this is kind of the way I just broke it down. Looking at the cost of dying, kind of broke it down into three separate areas. There's the legal cost of dying, and as well as the tax cost of dying. And then there's sort of the third category, which I'm not sure what I would call that. There's a bit of a control aspect to it. How much control do we lose when we die? Or can we keep when we die? Through the law, we can actually keep some control if that's important to us. But it's not just about control. It's also about just sort of some other personal type of issues. And so we'll talk about all of those. And that's kind of the way that I've broke it down in my head, and we'll talk about it. But again, I'm open to any other thoughts or comments or critique as we go. So from the legal cost standpoint, that's the easy one to tackle. In California, well, in most states, and really I'm licensed in California. So when I talk, I'm going to talk in general terms, and I'm going to talk about California because that's the law that I know. We have probate in California. California probate is undoubtedly one of the most expensive in the country. And the way I look at it and talk to people about is you can generally spend or plan to spend somewhere between 5 to 10% of the total value of all of the assets that go through probate. Those are going to get sucked away by the courts, by the lawyers, by all of the fees and filings and everything that you have to do through the probate process. So that is, for every $1 million, you're looking at somewhere between $50,000 to $100,000 in costs for your family to have to take your assets through probate. That's the financial cost of that legal process. There's also a lot of other costs that go with probate. There's a time cost. Probate is not fast. And before COVID, probate was really slow. And after COVID, they closed down a bunch of courtrooms. They haven't opened them up, and things are backlogged still. And it's going even slower. It's not uncommon for a probate case to spend a couple of years in probate. I almost never see them get through probate in less than a year. I mean, that's really unheard of. If you hit about a year, you're doing very well. A couple of years is pretty standard, and it can, if things go off the rails, it can be years and years and years. So there is a big time cost during that process. Also, here's what that cost really means: is all that time that assets are in probate, the family has little to no access to those assets. If they want access, they have to petition the judge. That costs money. You have to go to a lawyer. They're going to write a petition and get it on the court calendar to go in and argue that petition on why the family should have access. They're going to have to give the court a good reason, because probate is not there to protect your family. It is there to protect your creditors. And until all of the assets pass through probate and the judge says, okay, all the creditors have been paid, now the family can have whatever's left over, until that happens, those assets are really hard to get to. So be aware of that. That's the time cost and kind of what that really means in practical terms. And there's an emotional cost to probate too. Probate is not fun. The only people who enjoy probate, well, I don't know if enjoy is the right word, because I don't enjoy it, but the only people who really gain from probate are the attorneys and the court system, the people who are receiving the checks that are being written. So it's not something that you want to go through. There's no real upside to going through probate. That's really the legal cost. Then there's a tax cost as well. This is not really state-based. California does not have a separate estate tax or death tax, as it's often called. The California tax is really levied through the probate process, and that's part of why it's so expensive. That's where the state of California gets theirs, from probate. But there is a federal estate tax, and that right now, most of us don't have to worry about. And if you do have to worry about it, it's because you're doing very well. That's just under $13 million. It's $12.92 million. And it's adjusted each year for inflation. So it goes up, 3 or so percent every year. Right now, this year, it is just under $13 million. And that is scheduled to sunset in 2025. Meaning that it will roll back to what it was before this all went into place, which is going to be, I believe, $5 million. Now, that is per person. If you're married and both spouses are American citizens, you get to double up on that. So you're up at almost $26 million for married spouses. Right now, in 2025, that'll settle down around about $10 million. So again, if you've got an estate tax problem, it's because you've got a lot of money. So it's a good problem to have, but it's also a big problem to have. The federal estate tax is this tiered thing, but it tops out at 40%. So it can be a substantial amount of money that goes to the federal government instead of to the people that you want it to go to. That's out of your estate, out of your assets when you die. And then for that third category that I wasn't clever enough to come up with a name for, so we'll call it control right now. With that loss of control, when we die, everything is handled through statutory law. And so each state, each jurisdiction, and really by state, has their own succession plans, their own heirs. And in California, that means we don't really have control over what happens to our assets. They're going to go according to California law to our heirs. Who California says are our heirs, how much goes to each of those heirs. And so you don't have any control over how that goes. And that's really where trust law comes into play, because trust law is meant to deal with all of these issues, all of these costs of dying. And one of the big goals of this area of law is to keep as much of your assets in your family as possible, and as little of it in the government's pocket as possible, as legally permissible. So we work within inside the confines of the law there. And so just as any questions about any of that, or any comments, anybody want to throw anything in on those kind of main issues? And then I'll talk to you a little bit about what trust law does in a general sense to address each of those. And then we can drill down into the nitty gritty. Anybody have anything to throw in or
Oh, me.
add?
I'm just curious as to who came up with the death tax.
That I don't know. That's
We work all our lives to build something and then we die and the government thinks they have a right to it. I don't understand.
well, it's interesting, and that's a great question, Peggy. And I would love to do some more research on that, and give you a specific answer to that. I'll give you kind of what I think is the general answer. I believe our founding fathers would have fits if they knew this was going on right now. It was not back at the very beginning of our country. So this came about sometime in the 1900s when we got very tax happy, and a lot of the new taxes started that we didn't have at the beginning. I don't know exactly who it was that came up with this. I could guess, but I don't know for sure.
Not a rich person, I bet. Okay, well, anybody else have a question or a thought? Okay.
All right. Well, so again, please feel free to interrupt, and you're not interrupting, but throw up your hand or just jump in and add away whenever you've got something. But generally, trust law is designed to address all of these issues. So the first piece of that is, and let me kind of go back and explain why probate happens. And part of it is a bit of a money grab, I think, from the state. Part of it too, though, is the very legal issue that when we die, we can no longer sign our name on a contract, right? While we're alive, we can sell property, we can buy property. I mean, you have to sign your name, 1,000 times on all the escrow documents if you want to buy real estate. But it is that simple as signing our name. Once we die, we can no longer sign our name. And so it, in effect, takes a court order where a judge signs our name for us, for lack of a better phrase. And that's what probate is to go through all that, make sure that everything is done right. Again, all the creditors are paid off, big part of probate. And then at the end of that, the judge orders our assets to be distributed to our heirs. And that, in effect, is signing our name when we can no longer do that. So that's anything that is in our name when we die is subject to probate, has to go through probate. If it's above a certain amount, we have, it's about $167,000 right in that area, that if our assets are under that in aggregate, so they take everything that we've got. And so as we're a real estate group, we know that if you own real estate in California, most likely you're already way above that minimum. And so probate is what we're looking at. But if we're below that, we can I can do some legal paperwork that can avoid probate. You still have to go see a lawyer generally to do that, but you can get those assets distributed without probate. If it's above that, the courts and the state want a piece of that, and so they're going to suck you into probate. And that's where that goes.
Love the way you put that.
Okay, so that gives you an idea then of what's in your name is going to be put into that probate. Anything that you put in a trust is no longer in your name. A trust is its own entity. Now, we use what we call revocable living trusts. Sometimes they're just called living trusts, or sometimes they're just called revocable trusts. Those all are synonymous with each other. That's all sort of the same type of trust. An RLT, or revocable living trust, is generally what you put assets in to keep them out of probate. And that's the main thing that does, is keeps them out of probate. So you avoid that legal time cost, all those things that go along with probate when you have assets in a revocable living trust. Anything that you don't put in a revocable living trust and you leave in your name is going to be subject to probate. So this is a great point for me to pause real quickly and just tell you one of the most important points that you need to know when you set up a trust. I'm a proponent of doing that through a lawyer. You can go online now and do that for a few $100s. But I also do probate work, and you'd be amazed at how many trusts that people did online that end up in probate. So even though they thought they were saving money at that time by only spending a few $100s on their online trust, their family then is spending all that money to go through probate. And sometimes those probates get very complex because the trust actually can make things worse if it's not done well. So be aware of that. But even if you have a trust, whether you do it through a lawyer or whether you do it online, that is not the end of the game. That does not protect you. You have to then take your assets and you have to retitle them in the name of your trust. If you do not do that, if all you have is that trust that says, this is my trust, here's how everything goes, I don't have to go through probate, that is not going to get you anywhere if you don't have those assets retitled into the name of that trust. And that means really almost every asset. There are some assets that are exempt from that. Your qualified retirement plans, your 401ks, IRAs, 403bs, those kinds of plans, generally they cannot be held in a trust. And so those will follow however the designated beneficiary is listed on those accounts. Sometimes we want to list the trust as a beneficiary on those accounts. Sometimes we don't, because those can pass outside of probate. And life insurance is the other big asset that is not going to be subject to probate, whether it's in a trust or not. So those are the things that you don't necessarily have to worry about, but everything else, and real estate particularly, because we're here, that is one of those things. You've got to retitle the deed and get that recorded at the county so that the deed holder is the trust, not yourself as an individual. If you're on that deed as an individual holder or as a joint tenant or a tenant in common when you die, well, not as a joint tenant. A joint tenant would automatically go to the surviving joint tenant, but a tenant in common, that will be probated. And then even with joint tenants, the last joint tenant to die, that's going to go through probate at that point as well. Okay, so that is that kind of tackles that issue. Let's move on to taxes. So again, taxes aren't a state function. That's more of the federal function. And a living trust does not avoid those estate taxes. It's a really sort of interesting legal concept. Anything that's in a living trust is taken out of your estate for probate purposes, but it is not taken out of your estate for tax purposes. So anything that I put in a revocable living trust, so if I have $15 million worth of real estate and I have it all retitled correctly in a revocable living trust, I can avoid probate with that. But Uncle Sam is still going to come over and say, hey, you're above the estate tax threshold, so we want our death tax from you. So we then have to get a little bit tricky, and those are generally advanced estate planning issues. When we deal with that, we're looking at usually a combination of irrevocable trusts. Why we don't use irrevocable trusts from the get-go is because those are more expensive to set up and more expensive to maintain. Those are an actual separate entity from you. So when you set up an irrevocable trust, you are filing for its own EIN, its own tax number, because it's filing its own tax return each year. And so that gets more expensive because you're preparing an additional tax return, you're filing those taxes, and dealing with all of that. And there are some upkeep requirements that the IRS wants to see on those as well to make sure that they are a separate entity from you. But that is how you avoid that federal estate tax, or you keep your assets below that threshold, that 12.92 million. Or again, if you're a married couple, you can double up on that and you get a little bit more of a cushion. Okay, and then to go over to the control issue, one of the really cool things from my perspective as a lawyer that I get to do with living trusts is we get to be very creative. And really, the way I look at it is if we're not trying to do something illegal, we can do what we want. our only limit is our own creativity. So you can do things through a living trust, like keep control of those assets. And I've had clients who, may be a little too controlling from the grave, but that's not for me to say. It's their money. They get to decide what they want to do with it. But, I've had clients who say, okay, this is going to go to my son, but if he marries his girlfriend, who I do not like, he gets cut out, right? He doesn't get this. So you can do some of those kinds of things. But one of the most powerful things that I really love and have done for my children is my kids are still teenagers, so they're hopefully a long way off from getting married and going through that. But I have written my trust in such a way that if they get divorced, even if it's 10, 15 years after I die, after they receive their inheritance, and they get that divorce, that ex-spouse can't come in and take what I've left them in their inheritance. And now let me also pause here, because if any of you are versed in the law, you will know that inheritance is not subject to legal action. However, the reality is that when you get assets from an inheritance that aren't subject to a legal action, there's often what we call commingling. So you have assets that are subject to that. And this goes to community property as well, which California is a community property state. Community property is anything that you earn or acquire during marriage is going to be considered property of the community, of the marriage. Anything that you acquire before marriage or through inheritance during marriage is going to be your separate property, not subject to the community. When we divorce in California, that community gets divided up. Now, if we have separate property, that's not supposed to be divided up. But what happens so often is that separate property asset is commingled with the community property asset, and that can transmute it into community property. And so unless you can go back and trace it back to where it's separate property and prove to the judge that, no, that is in fact separate property, there's a good chance that that's going to be split up too for any kind of legal action. I'm talking divorce, I'm talking lawsuit, I'm talking bankruptcy, any of those kinds of things where the law is getting in and dictating assets be moved from one person to another.
So Mark, hey, Mark.
Yes, ma'am.
Can you give an example of how you take we'll say an inherited property and turn it into community property? I know
Absolutely.
it myself, but let's hear it from you.
That's a great question, and it's such an important concept. And so this happens all the time when people aren't even aware that they're commingling and transmuting this. So a lot of times that is, if I receive an inheritance of $100,000 and I throw that in my checking account, with where my paycheck goes, then I've just commingled all those funds, which means when I write a check out of that, there's no way of knowing which part of that comes from. It's all sort of going to be considered that one account, and it's commingled now. And then that's going to be, again, if I'm married, that's going to be considered community property. Another thing that happens that I've seen a lot is, let's say somebody inherits a property, a real estate property, and they do keep that separately. Either they put it in their own name, or they follow my advice and they put it in a separate trust has only their name on that trust. That's going to be separate. But then if I take my checking account, which has my paycheck going into it, which has community property funds going into it, because I'm married and I'm earning those funds during marriage, and I write the mortgage out of that, or I write my property tax bill, or I take out insurance, or I pay the guy to put on new gutters on my house out of that, I've just put those community property funds into that separate property asset, and that begins transmuting it into community property. So again, that happens. A lot of people know they need to keep it separate, but they don't think about that using one type of asset to improve that other asset, and it can really catch you bad, again, if you have legal troubles. This is really about legal issues down the line, which none of us know if we're going to have. So I love that protection in there, so that if it does happen, we're protected. But yeah, does that answer your question, Peggy?
Oh yeah.
Okay.
Happen
so those are some of the examples I've seen. There are other ways to do it as well.
Yeah, the spouse could write the check, and then
absolutely,
right now you've really messed up, because now the spouse is writing the checks. on that.
Absolutely. Yeah.
Yeah.
There's all kinds of things that can happen and go bad that way.
Yeah. So I would presume as an attorney, you tell them this property is in a trust or is an LLC and needs to have its own checking account, and the money needs to own.
Yes, absolutely. Yeah, excuse me, I've got an alarm going off. My apologies.
Okay.
Okay, I'm done. Yeah, so right. So if you have real estate in a trust, you always want a bank account that is also in that trust, so that if you need to pay something on that real estate, particularly if you've got a mortgage, but we all have property taxes, and if you need to do repairs and improvements, that should come out of that as well, so that it is all trust funds going into that trust asset. That's generally the way we would want to do that.
Mm-hmm. And hopefully there's income, and that would want to be put in that separate account.
Absolutely. So those are kind of the three issues, the three costs of dying, and some ways that you can get around those through using trust law and trusts. And any questions on any of that? Anybody have any comments or anything else? Yes, Peggy. I knew you were going to have more.
Wow. Can't help it. Stuff keeps popping into my head. I'm sure with everybody else too. So when you were talking about everything that's in your trust needs to be titled in the trust, but what about people that have their personal property? Who cares about the furniture? But if they've got jewelry, they've got beautiful dishes and silver, and they might have silver and gold also. They might have antiques that, well, I don't know antiques have any value right now, but at one time they did. Paintings, artwork. How is that put into the name of the trust?
So at my firm, when they're signing their trust, they're also going to sign a document that says any personal property I now have or acquire in the future, I am donating to my trust, and boom, that gets it right in the trust.
Oh,
so
okay.
Because personal property, that's your clothing, jewelry, furniture, pictures on your wall, junk in your garage, all that stuff doesn't have its own separate title. So that is how we get that into the trust. Anything that has its own separate title, so deeds, titles to your car, although let me put an asterisk by that. We'll go back and talk about that because cars are generally a little bit different, but bank accounts, any type of financial account that is titled in a certain way. So anything that has its own title, we want to title that asset according to how it is titled in the name of the trust. If it does not have its own title, i.e. personal property, we're generally going to do that through a memorandum that we attach to the trust and sign and say, this is what we want to have happen to these assets. Now, cars, I said that's going to be a little bit asterisk. I generally don't put cars in the trust unless, you're driving around in you're probably not driving around in it, but if you have an antique or collectible or, an old Aston Martin or something that's really high value, that we want to get in the trust. But for most of our everyday transportation, we generally don't put those in the trust. And here's why. Because insurance companies really don't want to offer insurance to a trust. They want that in your personal name. So the amount of insurance companies that will insure a trust-owned vehicle goes down. And when the supply goes down, the cost goes up, right? So you're going to pay more for that insurance to get it insured if your vehicle is in the name of a trust. And we try not to do that to our clients, try to let them pay as little as possible for all these things. So we generally don't do that. Now, the trick around that is you can do a transfer on death on the title of that car, and you can either go stand at the DMV and do it there if you're a glutton for punishment, or if you want to make things easier on yourself and you have AAA will actually help you do that. You can go to AAA and they will help you do a TOD on the title of your car. And that basically you're just going to put a beneficiary there that says, when I die, this immediately goes to this particular person without having to go through probate. So that's how we generally recommend our clients deal with automobiles.
And you could do that after, or you could do that anytime.
Anytime, well, you still have capacity. So all the tricks we're talking about, all of trust law has to be done while you're alive and while you have mental capacity to understand what you're doing and to sign your name and in a state that you understand what you're doing.
Right. So if you have a car, I have a car, and you never know if you're going to have an accident, and people have. And so can you do that anytime? Do you have to wait till you're a certain age or any of that, or can you just
Well,
have?
you have to be an adult under the eyes of California, and so that's 18 in California. But any adult can do this as long as they have capacity, and that's a capacity is sort of a quasi legal and medical definition, and really it comes down to, do I am I in a state where I understand the consequences of my decision? And then there are some, we can drill down and go crazy here, because then there's, okay, well, maybe I had capacity, but was I under undue influence, or was I being coerced into put Peggy down as my beneficiary on my car? Was she holding a gun to my head and saying, you better write my name down on this? Those kinds of things. So
Does this have to be recorded?
well, it's on the title, so
It's actually
not
on
it's,
the title.
yeah, it's
Oh,
on the
okay.
title.
Oh, okay. Yeah, so it's
So the only thing that we really record are deeds, and that's going to have to be recorded for the county to recognize the transfer and ownership. Otherwise, there's nothing else that we record. That's all kind of handled outside of the recordation process.
Okay. Anyone, Ted, you have any questions or comments?
I have a question.
Oh, good, Tina.
Can banks lend to family trust?
They can. They don't like to do that either, is my personal experience. But so a lot of, and that's a great question, because this is something to be aware of. If you have your property in a trust and you go to refinance it, a lot of times they will pull, the lender will want that property pulled out of the trust and put back in your name, so that you're signing the loan as an individual rather than as a trustee of the trust. They don't always make that clear to you. So I've had people who've passed and their house gets pulled into probate, and they come to me and say, oh my gosh, we did this trust so many years ago. Not with me, because I keep up with my clients and I let them know this story. But if it's somebody else and they don't keep up with it, they can be pulled into probate, because that house is now out of the trust, because it never got put back in, because they didn't even realize it came out in the first place. So if you ever refinance or take any kind of a loan against your property and you have it in a trust, you always need a good attorney that you can say, hey, check this out, make sure it got put back in the trust for me, or you need to know to do that yourself. And that looks like, getting on getting down to the county recorder and doing a property search and finding out how your deed is titled. Did you just take it out of the trust when you signed all those escrow documents? And you probably did. And it probably did not get put back in.
And you can actually ask the escrow officer to create that deed to put it back in, and she will do that, right?
Ask them. Whether they do it or not, they probably won't, and it's a liability thing for them. So that's why they don't usually even tell you that they're doing that. They don't offer to put it back in, and sometimes when you go to buy a property, and so when I buy a property, I always ask them, okay, can you put it in the name of my trust? A lot of times they won't even do that. So then I have to go file a deed right after I buy it that transfers it over to my trust.
Right. Well, we've had escrow officers that will record it the following week to put it back in your name, because they have to do the transfer information too. And they need the first one recorded before they do the second one. There are some that will do that.
There are some that will. There are definitely, and those are great when you find them. But my experience is a lot of them will not do it.
Yeah. Well, there's that. Some of them have been educated, and they now are working with. They're working with trusts. And Cliff has a question. So go ahead, Cliff.
Hey,
Cliff.
so thank you. Hello. What is the process of moving a property into the trust? Is that
So-
something you can do on your own? Do you have to go through an attorney or a title company?
You don't have
And
to, but
then-
it's technical. So I would be very careful because, a deed is not something that you want to mess up and have a chain of title issue later on that your family has to be stuck dealing with. So I always recommend go to a professional who knows what they're doing and also has some liability insurance so that if something does go wrong, they're on the hook, not you, because you're going to be out in the cold if you do something wrong on a deed. So it really is just a matter of recording a new deed, and we usually, I've seen a lot of attorneys use quitclaim deeds. I don't like that because that has its own chain of title issues with a quitclaim deed. So I always use grant deeds, and so we use a grant deed that grants it from you as an individual directly to your trust, and we record that, and then boom, it's in the trust. And that's really the process.
And then you have to get title. You have
Okay.
to inform your title insurance company about the transfers. Otherwise, you have broken the chain of title, and it's very difficult sometimes to sell because that chain got broken, and they don't like that.
Thank
So-
you, Peggy. That is true. And also, along with that is your homeowner's insurance policy. When you do transfer a property into the trust, you should always make sure that the trust is added onto that policy as an additional insured.
Right. And the other thing
That
is,
makes sense.
when you do a grant deed, I would think that most counties have, this is just California that I know about, it's called a preliminary title change or something like that. And there's a whole bunch of check marks for you to fill out on that. And one of them is it still the same owners so that your property taxes don't go up, which in California is very important because we're still under, thank goodness, under Proposition 13, which they're trying to get rid of one more time.
They're going to try till they get it. We just got to be on the guard for that.
Yeah,
But
well, they have
yes,
something
Peggy, you're
coming up.
right. So what happens is once that deed goes to the recorder's office, they're going to stamp it, and then they send it right next door to the assessor's office, because anytime a title changes hands, the assessor wants to come out and reassess that property to raise those taxes. So you have to have that preliminary change of ownership report that goes along with the deed that says, no, we are claiming an exemption. One of those check boxes is we are exempt from a property tax reassessment if we are transferring our own property into our own trust. So we check that box, we have it all filled out, we send that in with them so that they know they don't send that over to the assessor's office after they stamp it. They just keep it. That takes care of that.
How would that impact areas where there is homestead for taxation?
I will tell you, I don't know. I'll tell you my experience with homestead is that as part of California law, we all have homestead protections. And so that's not something that you need to worry about separately. Although, again, my experience is that whenever these deeds get recorded, because it's public record, everything that goes through the recorder's office is a matter of public record. Clients will get letters that look very official that say, oh, you need to pay us, $250 to get homestead protection on this property. And it's not an official letter. It's from somebody who goes down and reads the records and realizes that this property just went through this process, and they're sending out these letters hoping that somebody will send them a $250 check. So be aware of that. You don't need to do that. This is what I tell my clients. You already have those protections inherent within California law, so you don't need to do that. And I don't think that directly answers your question, Cliff, but that's
Quite.
really,
Yeah, because like for
I'm not
example, in
familiar
Florida,
enough
you have
with-
homestead.
yeah, I apologize. That's my limited knowledge of homestead. So I'm trying to do the best I can and give you what I have, but I don't know the direct answer to your question.
Well, homestead will
appreciate it.
protect. So Cliff, homestead protects you to a certain dollar amount, and the people that want to get around that homestead are usually people that want to record liens. So people will record a homestead so that equity, certain amount of equity, is protected against anyone who records a lien against the property, such as if you had work done on the property and they and you didn't pay the bill, they're going to record a lien. In California, they have to have done a whole bunch of things before they can record that lien, but people can record liens, right? So that's what the protection is for.
I have
And one
another
other thing that I'm sorry, was there another question?
question. When would you go from revocable to, what was the other one again?
Irrevocable.
Irrevocable, sorry. When would you use one
So
versus the other?
there are all kinds of little minute reasons that you might do that. The big reason is when you have an estate valued at more than the federal estate tax minimum. So like I said, right now that's at 12.92 million per individual. So if you're married, you get to double that up. You don't have to worry about it till you're up at the $26 million mark. If you're single, you're worried about it when you head up to the $13 million mark. That's when you really need to start thinking about it. But there may be some other reasons in between there that may make that make sense. But in general, I try not to do that unless there's a real good reason to. So usually that's the estate tax that we're worried about that helps with.
Thank you.
Yeah, you own a high rise in Manhattan or downtown LA that's a 60-story building. That might want an irrevocable trust.
And one other issue that I want to just quickly touch on, because we're a real estate investing group, a lot of people, if you have income properties, you're going to put that in an LLC for liability protection purposes, which I think is a great idea. Within reason, because I have a lot of people who come to me and say, oh, I want to put my property in an LLC, and they've got a mortgage on that property. And you need to be very careful by just doing that, because that will trigger that due on sale clause. And that could be a big problem if that happens. So you don't just do that willy-nilly. Just throw a property into an LLC unless you've sort of crossed all the T's and dotted all the I's, and make sure that you're okay to do that and there's no negative surprise. I don't like surprises, and I know my clients don't like surprises. So you want to make sure that you're not setting yourself up for a nasty surprise down the line. Now, if you do have a property in an LLC, that doesn't mean you can't use the trust to avoid probate. And just because you have it in an LLC, it very well may be subject to probate. So what we do to get around that is, instead of you and your spouse being the managing member or the members of that LLC, the owners of that LLC, you're going to make the trust the member and owner of that LLC. So in effect, the LLC owns the property, the trust owns the LLC. Then you get that double layer of protection. You get the LLC's protection for liability, and you get the trust protection against probate.
Brilliant. Yes, Ted.
Mute here. What do you think about the idea of doing the equivalent of a fire drill, pretend death, to see, just to see, let's say with your attorney, to see what happens?
By whom? Who are you going to who are you testing? Who's your fire drill, or what is your fire drill testing?
To see whether or let's say to see what problems might occur if somebody died.
Well, I think, I guess I would say, I'm not sure how you could do that, because in any kind of legal proceeding, if there's a death, you're going to need a death certificate. So without a death certificate, you're not going to get very far in that fire drill. And then obviously, if you're not really dead and you have a death certificate, somebody's going to be committing fraud, which I would never recommend doing, because that's just not going to end well. So I don't know that it would really work.
What's the significance of having a death certificate if the activity was basically pretend anyway?
Well, I guess I'm just looking at it. If you're going to go through the court process, they're going to want to see a death certificate before they open probate, because they're not going to want to go through. It costs money. So I don't see. I've never heard of that, and I don't see that happening and
would
being
the
a
court
realistic thing.
why would the court have to be involved in that kind of process?
Well, if you're talking about doing, maybe I'm misunderstanding the question, but if you're talking about doing a pretend death to see how everything happens, then part of that is going to be seeing how the court reacts to that, I would think. I don't,
would think
I'll tell you,
I think it would
Go ahead,
mostly
Ted, I'm
be the
sorry.
parties and the attorneys that would be involved. wouldn't it?
Well, I guess I would say this as an attorney, what I do is I want to make sure that I understand all of my clients' documentation and goals, and then we talk through that so that they know exactly what's going to happen. And then we can look at, okay, is that meeting your goals? If it is, great. If it's not, here's what you need to change about your documentation to meet your goals. So we kind of do that exercise anyway, but not necessarily as a pretend death, but just as a working through that. So if you have a good attorney, that's part of what they should do for you is look at your documents and make sure that you understand exactly how things would go down if you were to pass right now based on what you have in place.
I guess I don't see any, attorneys that would claim to be as good as you do.
Oh. Maybe you need to
They're
ask
out there.
question.
There's good attorneys out there. You do have to look, and you have to pick up a lot of rocks and deal with a lot of snakes. I know, but they are out there.
And who knows, Mark might know somebody in your area. Hello, Henry. Welcome. So does
I'm
anyone
here.
else
Is
have?
it too noisy? I'm gonna mute myself out. I'll just
I'll mute you. Yep. So does anyone else have any other kind of question? I mean, I think it's very interesting what Ted asked. Yes, you want to know how things are going to go, but you could actually do a walkthrough yourself.
And Ted, that's a great. I apologize. I got caught up in the pretend death, but I think where you're going is great. And yeah, you should know that. You want to know that, and also your family. I think it's a great thing when your whole family really gets involved in this and understands what you've got in place, how you want things to go. It's one thing for them to read the documents. It's another for them to hear our voice and say, this is what's really important to me. This is what I want. Here is where everything is. Here is the instructions that you need to follow, and kind of doing maybe not a walkthrough necessarily, but a education on here's where I've got everything. Here's what your instructions, follow this. Here's my lawyer, call them. Here are the important people in my plan. Here's how to get a hold of them. Just set it up. I mean, it really is all about making this as easy as possible on the people that we care about. And so having those conversations beforehand helps facilitate that. Even though those conversations are sometimes uncomfortable, I find that they're better to have than to just kind of stick your head in the sand and act like it's never going to happen.
I remember asking an attorney at one of our CPA Society meetings, chapter meetings, why he didn't talk about families that, let's say, where the spouse was married, or where the parents were married only once, and the children were married only once, and let's say people tended to, so to speak, parents died before children, all that sort of thing. And he looked at me and laughed, and he said, "There's no money in that."
One of the things that I did was I took a spreadsheet and I took all my personal property and wrote down what it was. And then I also put all my charge cards, where they are, who they're by, etc., all my bank accounts, all my passwords. And the one thing that I find is the most important thing to have is the password to your computer, because all that information's on my computer, and if they can't get there, they can't see the information. So it was also suggested that I do print a copy like that. So, and be
Yep,
sure
good
to put
job,
the
Penny.
password.
That is important.
So that helps. We've never sat down and talked about that. Nobody wants to talk about death. There's something about death that people want to avoid, and yet it happens to everybody. I know no one it hasn't happened to, except all those people that are still alive, of course, but yeah, okay. Nobody else laughed, huh? Okay. Naked did, of course. Yeah. So does anybody else have a question or a thought or something they'd like to know? Henry, you kind of missed most of it. Bubba, you missed a little bit of it.
Yeah, sorry, I had something on. I will catch the recording after you send that to me. So, was there any discussion about writing a letter to the people who will help with the executive, basically a letter to the executor? Besides that, I mean, you can write it to your children too, right? Basically your wishes over and
Yeah,
above
yeah.
the plan.
Yeah, and I didn't talk about that, Henry, but that's a great point. So, for my clients that have minor children, we help them write a letter to their children and to the guardian that they've named for their children. And it's not a legal document, but it a lot of this goes.
Oh,
Uh-oh.
did he got cut out?
He hit the wrong button. He'll be back in a
Yeah.
minute.
Yeah, in the letter, don't you want to say where the passwords are, what accounts are, and all that too? It's more than just the information to
Yeah, where
the exit.
yeah, that's what I did. I did a spreadsheet. I have a spreadsheet with all of that on it, but you have to tell them where that is so they can find it. I mean, your
Do you have
spreadsheet.
a letter? They have a letter that goes with the spreadsheet.
Well, I don't give them the spreadsheet. Yeah, you give them a letter. Well, you have your trustee
Oh, okay.
and you have your executor. So I expect he will get back on in a minute. But yeah, you do what he's talking about is what you just said. What you want needs to be made clear to your whoever is a beneficiary. Could be your spouse, could be your children, could be your grandchildren, could be friends. Lots of people give stuff to their friends. But yeah, for sure you want to write your children, and for sure you want to write your executor.
Okay.
Okay.
Thank you.
Of course. Yeah. And yeah, Mark's really great. So it'll be a good recording when we get done. Hopefully Mark can get back on. And if he can't, we'll give him 2 more minutes. And we're at the top of the hour almost anyway. So does anyone else have a question or a thought? Ted, did you put your hand up? Ted left also.
Ted left.
Ted left. All right. So thank you everyone for coming. We really appreciate it. We really thank Mark for his information. And if you want Mark's information, just send me an email and we will get that information to you. And do keep in mind, Mark is California only. If you're looking for someone in another state, he does have a group of attorneys he works with, and he might be able to give you a reference. So still send me an email and then I'll do an introduction. So thank you very much for coming, and we'll see you next week.